And Mr. Tannen and Ms. Johnson, are you doing the argument today, Ms. Johnson?
Good morning, Your Honor. Yes, I am.
Okay, very good. Then Mr. Gomez, I'm sorry, hang on one second. Let me straighten this out real quick. All right, I've got it all set. Ms. Johnson, we are ready.
Good morning, Your Honors. May it please the court. I would like to reserve 5 minutes for rebuttal.
Very good. And you may proceed.
Thank you, Your Honor. This case began on November 1st, 2016. The appellant was charged by information. In Polk County, he was charged with conspiracy to traffic and amphetamines. He was charged with trafficking in amphetamines, possession of drug paraphernalia, and a manufacturer sale of controlled substance. The Polk County Sheriff's Office conducted an investigation back in October 12th, 2016, when they began an operation with Detective Sains and Detective Starr. Were looking into a possible drug operation. Detective Sains was doing phone calls with some unknown gentlemen on the telephone. He was receiving information that there was a potential
Counsel, let's kind of get right into the issues. I think we've all read the facts. The number one issue that you have a concern about is the testimony of Detective Sains. Is that right?
That's one of the issues. Yes, Your Honor. Detective
That's your first issue?
That's the first issue that we listed. Yes,
I guess my question for you would be, you've relied heavily on our case, Antunes Salgado case from 2008. It's your good fortune to have the author of that opinion on our panel today, Judge Volante, so perhaps he can do a better job of dissecting this than I can. But it seems to me that our case is different in that in our case, Detective Sains is testifying about what led up to this drug transaction. There somehow has to explain how Mr. Bragan ended up from Georgia to a parking lot in Davenport, Polk County, Florida, with 2 kilos of meth, other than this story that he gave about meeting these fishermen and delivering documents. But it seems to me that the case that you cited, Antunes Salgado, is a different situation, because there the officer is testifying about post-Miranda, post-arrest statements, rather than statements that explain or lead up to the actual drug transaction, which is what we have in our case, which appears to be a lot closer to a verbal act or a co-conspirator statement, as expressed in some of the cases cited by the state. So help me out here and tell me why you think Antunes Salgado case is a winner for you.
It's a winner in the aspect of the acts by Mr. Bragan is, number one, let's go with verbal acts. It's not a verbal act because there is no evidence that whatever conversation Detective Sains may have had with either of the gentlemen on the phone, there's no evidence that it had any effect on Mr. Bragan himself.
Well, somehow Mr. Bragan had to know that what he was supposed to do was drive his car with Georgia plates down to Polk County, Florida, and deliver, quote, shoes. How would he have come by that information? What other explanation is there other than that there were conversations that arranged this deal so that he could be where he was supposed to be, when he was supposed to be there, with the exact type of drugs he was supposed to have with him?
Well, just because he arrived at the exact location does not mean that he had any conversation with any of the other co-conspirators. If we're, going to go with that route at this moment, there's no indication that he had any conversation with them.
Well, didn't Detective Sains testify that he actually overheard Mr. Behar Islas speaking with Mr. Bragan? I mean, wasn't that in the record?
I believe that was in the record, that he overheard them at the time that they were at the location, but I
So
don't
we-
believe
so
that
we
they
do
had
know
any.
that they were at least were in phone contact at the time that Mr. Bragan arrived, so that Mr. Behar Islas could direct him where he was supposed to bring his car and park and so forth. That they were talking. If the record's clear, they were talking at least at that point in time, correct?
Correct, Your Honor, but that was not anything with regards to the drugs, the amount of drugs, what kind of drugs. That was with regards to innocent acts, with whether or not where he's going, what, where he needs to go with far as directions with regards to the location of Posner Park. That was not with regards to anything of illegal activity with so far as the drugs. So there's no indication that any of the conversation with regards to the drugs, the amount of drugs, what kind of drugs, or anything like that, that Detective Sains indicates that he had with each of the individuals on the phone had any type of effect on Mr. Bragan himself.
But
Mr. Bragan,
otherwise, how would Mr. Bragan have known what type of drugs and what quantity of drugs and what the pricing was if those conversations didn't take place? I mean, he had to, at some point, he had to learn what was expected of him.
Mr. Bragan himself testified that what he went down there for was to deliver documents.
I understand that, but there's the testimony in the record is when he comes to the parking lot, he's directing Detective Sains where to park his car and how to position the hood, and here's your shoes for you. He doesn't say anything about documents. He says something about shoes, and they open up the package, and then he says, "Oh, that's looks good," and he says something about it being pure. I mean, all that's in the record, correct?
That's in the record from Detective Sains. Yes, Your Honor. That's questionable as to the audio recording that was in the a record that at very specific times of that audio was cut out, that you could not hear or understand what was going on. So Detective Sains did testify to those particular things that Mr. Bragan said at those particular times.
And there's no other explanation for why Mr. Bragan shows up when he does, where he does, with the drugs that he's carrying, other than somebody had to tell him that that's where he needed to be. And we do know that he was in phone contact with Behar Islas.
Well, the explanation is Mr. Bragan himself testified that he was going there to that location with documents, because the record also indicates that he never opened up that bag or that box, because it was actually, the box was inside of a bag. He never opened up, it was closed. That it indicated that it was not opened until Detective Sains testified that he's the one that opened that up, that it was not open prior to that. He opened it up and checked it out. So Mr. Bragan did not open that up, which also goes to our issue number 3 with the willful blindness. The state asked for the willful blindness instruction, which our position is never should have been given, because the state indicated that they requested the willful blindness instruction because he intentionally, because for the willful blindness, of course, it has to be, an intentional act for him to try not to discover what was discovered.
Let's talk about that for a minute. I mean, does
Sure.
just from a logical perspective, from a common sense perspective, does Mr. Bragan's testimony about what he thought he was doing make any sense? For example, he's offered $500 to make a delivery of documents that could be handled by FedEx or some other means for $15 or $20. He barely knows the people that he's supposed to be carrying documents for. And he's given a shoebox, which seems like a pretty peculiar way to carry documents, a shoebox inside of a bag. And I know he said, well, I wasn't suspicious until later, but I mean, really?
Well, he's an older gentleman, and he, was at this fishing place with these people, and some of the older generation don't question things, like us younger generation do. They don't question things, like they probably should. They're a little bit more susceptible to things.
Ms. Johnson, what you just said seems to me to go to the heart of why the instruction can be given in certain circumstances. Your explanation is a factual question for the jury as to whether his beliefs and his conduct whether those were reasonable or not. And isn't the evidence at least consistent with the idea that he was willfully ignoring what was happening and didn't really want to ask too much?
Your Honor, I would say no, because it's a deliberate avoidance. He, in a situation where he would be like, no, I think something is wrong and I'm not going to look inside of this package. That would be that situation. He's thinking that he's doing something with, for his fishing buddies. And, I'm just saying that sometimes maybe I'm indicating that sometimes maybe the older generation just do things out of the goodness of their heart and just, they probably should do that. I'm not indicating that that's, a good thing or a bad thing.
Assume for the sake of argument, I agree totally with you. Why is that still not appropriate for the jury to determine, including being instructed that you can determine whether or not he was being willfully ignoring the information that he had that a reasonable person would be on guard about or be suspicious of?
Well, in Solomon versus State out of the 4th District, 126 Southern 3rd, 1185 says the willful blindness doctrine is that if a party has a suspicion already aroused, but then deliberately omits to make further inquiries because he wishes to remain ignorant of that fact, then that is when the willful blindness instruction should be given.
Is it your position that any defendant's subjective view of the facts determines whether or not the instruction should be given?
I would say yes, Your Honor, because it's, the person has to have their suspicion aroused to have that indication that something is amiss, something is wrong with this particular incident. And then at that moment, then if they go to take steps to, and I apologize, Your Honor.
I was just going to ask, didn't the judge find just the opposite? That it was an objective standard, whether his suspicions were aroused, and if it was subjective, then you would never give that particular instruction. So I don't see how that can be controlling. I kind of agree with Judge Boto's take on this.
Well, yes, Your Honor. I mean, I agree that I believe that that's what the court said, but I mean, I think it's a little bit of both. I mean, the person has to have some type of suspicion aroused, right? So the person has to have, some type of inclination that something is going wrong, something is amiss here. So if there is nothing, to indicate that there's something amiss here,
Well,
then
what's consistent with this case being documents for a ranch being sold in Florida, being transported by this gentleman? What's consistent with any reasonable person believing that?
Well, Your Honor, I believe that the incident where Mr. Bragin indicated that he has, met these people a few times, that there was nothing amiss previously.
Call them fishing buddies, but now you're backpedaling. They're just acquaintances at most.
I agree that they're acquaintances at most. That he indicated that indicated that they were going down to, that he was going down to Florida, that they asked him to take these documents down there. I don't think that there was anything amiss. They asked him, it's personal documents. I don't think that anybody would want to go through somebody else's personal documents when you say, here, can you take this down to Florida for me? As you're already going down there. I don't think anybody in their, reasonableness would go through somebody else's documents after they've handed them to you. So I don't think that
isn't it reasonable to think that, this is not the way real estate transactions are handled?
Well, I don't know if it was really
here's a box of documents, we'll pay you $500, we barely know you. I know he's 71 years old, and I know you've said that the older generation is more trusting, but they're also have been around a little bit.
Yeah, I don't know if it was necessarily a real estate transaction. He was just asking him to take the documents down there. I don't know if it was actually like a transaction for him to go down there and file it with the bank or file it with somebody. He just indicated that, that they were, important documents. So I don't know if it was necessarily a transaction. So I would disagree with, the, title of a transaction. So, I think that, in all, I believe that, him asking for them to take documents down there, I don't think that a reasonable person would necessarily go through somebody else's documents. So I believe that a reasonable person would not, necessarily have their suspicion aroused at that point.
Do you think a reasonable person might say, why would you ask me to do this when you can send these down by overnight mail for $20.
Not necessarily. I mean, we all know that FedEx loses stuff, UPS loses stuff, the mail loses stuff. And if it's that important to somebody, they would maybe want to ensure that their documents get down there. And if they already had this relationship and they trusted each other, then they would, entrust somebody to physically take it down there themselves.
Ms. Johnson, you've used 15 minutes. You're at your 5-minute mark if you want to reserve for rebuttal.
Yes, Your Honor, I would like to. Thank you.
Very good. Thank you very much. Mr. Tannen?
Good morning, Your Honors. May it please the court, my name is Jonathan Tannen with the Attorney General's Office representing the state of Florida. On the first issue, the admission of statements by the detective where he described the phone conversations setting up this drug transaction, the trial court did correctly admit those statements on 2 grounds. First, that they were non-hearsay verbal acts. And second, to the extent they were hearsay, they fell within the co-conspirator exception to the hearsay rule. With respect to verbal acts, in order to be hearsay, of course, testimony has to be submitted for the truth of the matter asserted. When we're talking about conversations where a deal is negotiated, and specifically where a drug deal is negotiated, the statements are not being submitted for the truth of the matters asserted in the statements, but to show what the terms of the transaction were and to show that the parties thereafter acted in accordance with the terms of that agreement. And that's what we have here. The detective testified that he spoke to 3 men setting up the transaction. The first person he spoke with, he understood to be a middleman, and with that person, he negotiated essentially the terms of the deal, that he would pay $36,000 for 2 kilos of methamphetamine. He then spoke to the second man, who was represented as the owner of the drugs, and that man set the time and place of the transaction and advised that his courier would be coming from Atlanta to deliver the drugs. And then the third man was Mr. Behar Elis, who was the undercover officer understood was the first man's brother. And Behar Elis said that he would be at the transaction in order to essentially supervise it. And ultimately, the facts showed that was what happened. He met Behar, the undercover detective met Behar Elis in the parking lot. Behar Elis said that the courier was on the way. He talked to the courier over the phone in the detective's presence. The detective heard the courier over the phone saying that he was driving a Buick. And then Mr. Brogdon arrived in the parking lot in the Buick, parked next to Mr. Behar Elis, met the undercover detective and Behar Elis, asked about the money for the transaction, provided the shoe box, said he had brought the shoes the detective ordered. And then in the detective's presence, the detective opened up the box, inspected the drugs. The detective commented on the quality of the drugs, and Mr. Brogdon, according to the undercover detective, said that the drugs were pure. And so under these circumstances, the statements regarding the arrangement of the transaction are not being submitted for the truth of the matter asserted. They're being submitted to show what the terms of the deal were. As to the co-conspirator statement exception, to the extent these are hearsay statements at all, they also qualify as statements made by a co-conspirator in the course of and in furtherance of the conspiracy. As far as the argument that these statements had no effect on Mr. Brogdon's behavior, Mr. Brogdon, now obviously he testified that he didn't know this was a drug deal, but first of all, the jury was entitled to reject that. Secondly, the testimony showed that he was a knowing participant in the drug deal and that he knew what this was. Again, according to the undercover officer, he brought, well, not just according to the undercover officer, according to the facts, he brought the exact amount of drugs that were negotiated in the drug deal. He commented on the quality of the drugs. He accepted the money that was supposed to be paid. So the evidence, aside from the statements themselves, did show that he was a participant and a co-conspirator in this drug transaction. I would just address the Antunes Soldado case briefly. That case did involve different facts. In that case, all of the statements were reported as post-arrest, post-Miranda statements that were made by the co-defendants to a detective who was undercover, who was doing the interrogation. And in that circumstance, none of the actual co-defendants testified at trial. all of the testimony was through the interrogating officer who testified to what all of the co-defendants said after the arrest. And in that circumstance, first of all, the statements were not non-hearsay verbal acts because they weren't statements in the course of the drug deal setting up the drug deal. They were statements made after the fact explaining what the terms of the drug deal were and what the defendant himself actually did. And in that circumstance, the statements are being submitted for the truth of the matter asserted. They're not part of the drug deal itself. The court also held that the co-conspirator exception couldn't apply for two reasons. First, the statements were made after the drug deal, and in order to fall under the co-conspirator exception, the statements have to be made in the course of and in furtherance of the conspiracy. And statements made after the fact don't meet that requirement. In addition, there was a Crawford v. Washington problem there because none of the co-conspirators testified and were subject to cross-examination. So that was an additional problem in Antunes Salgado that we don't have in this case. So under these facts, the trial court did correctly rule that the testimony of the detective was admissible. With respect to the willful blindness instruction, this is reviewed under an abuse of discretion standard, and under the facts, the trial court did not abuse its discretion by ruling that it would give the instruction. Under the facts as testified to by Mr. Brogdon, the jury could make a proper determination that his suspicions were aroused under these circumstances, and that to the extent it believed him at all that he didn't know what was in this shoebox, it was because he willfully chose to remain in ignorance. His testimony was that this was discussed with opposing counsel, but his testimony was that some men he was fishing with offered him money to drive to Polk County and deliver a shoebox. Actually, his testimony was that the men didn't even tell him where he was going. They gave him a cell phone, and then while he was on the road, directed him where in Florida to go. The question of whether this was suspicious behavior or not was properly something for the jury to determine. And the trial court ruled that under these circumstances, there was a sufficient factual basis for the jury to find that the defendant did remain in willful ignorance. Additionally, under this record, while the trial court didn't abuse its discretion, we can see from the verdict that any error was harmless because the jury ultimately determined not just that the defendant knew what was in the shoebox, which was shown by the evidence, but that he was an intentional participant in the conspiracy. And again, that was supported by all of the evidence regarding the detective's testimony as to what Mr. Brogdon did on the day of the transaction. He spoke to Mr. Behar-Elis over the phone before he arrived. He actually inspected the drugs with Behar-Elis while the undercover detective was moving his car. And he commented on the quality of the drugs and then accepted the money when the undercover detective made the exchange. So under these circumstances, we can see that the jury convicted Mr. Brogdon of being an intentional participant in the drug conspiracy. It wasn't just that he had knowledge of the contents of the box. The second issue, the motion for judgment of acquittal, I don't believe was discussed during the appellant's argument. I would just rely on the brief for that and say based on the evidence discussed relating to the co-conspirator exception, there was competent substantial evidence in this case to support the denial of the motion for judgment of acquittal. If the court has no questions, I will rely on the state's answer brief for any further arguments, and the state requests that judgment and sentence be affirmed.
Thank you, Mr. Tennant. Ms. Johnson, you have your rebuttal time.
Thank you, Your Honors. Just briefly to something counsel indicated with regards to the co-conspirator hearsay, we would argue that that does not apply to get the statements in this particular case. If that were the issue, then you can almost get any kind of statement in on any case. You can say that, you know, you're having a conversation, an innocent conversation, and then all of a sudden it's used against you as co-conspirator hearsay. Just because you're having a conversation, which in this particular case, They cannot even indicate that Mr. Bragin was part of, again, any conversation with any of these men, with Detective Sains, with any, the first man, the second man, or the third man, with regards to anything having to do with the drugs or anything of the like. With regards to the argument, again, of the verbal acts, we indicate, as I indicated before, again, none of those conversations were with Mr. Bragin. Mr. Sains did indicate that he had a conversation with 3 different men, but again, none of them were with Mr. Bragin, and there's no indication that it had a specific effect on Mr. Bragin himself. We did not, I apologize, get to our issue number 2. The council just briefly notated on with regards to the trial court erring and failing to grant the motion for judgment of acquittal as to count 1, the conspiracy. That goes to our previous arguments that there was insufficient evidence in the particular case with regards to the conspiracy itself. As indicated, there's no indication that Mr. Bragin had any conversation with any of the previous callers with Detective Sains, who he had previously spoken to. The court erred in granting that motion. There's no indication that he had any knowledge of the particular crime, even aided or abetted in the crime itself. But the court erred in granting that motion. So we ask that the trial court, the court reverse the trial court's order and grant a new trial with respect to this case.
Very good. Thank you very much, Ms. Johnson and Mr. Tannen. The next case on the docket is, forgive the pronunciation, Snyders versus Estate of Schaefer.